Let us look at situations involving building defects and how they are viewed in tort law. So as you guys are aware, the owner of buildings, they do change rapidly over the years. When you have an owner, say, for 5 years, and then they sell it to someone else, and then that person sells it to someone else, the ownership keeps on changing. Now, the problem is that defects only become apparent, most of the defects, especially the important ones, only become apparent several years after the building is complete. So the ownership would have changed several times maybe. What's the issue? The issue is that you don't have a contract over here between the subsequent owners and the designer, the build or the builder that was involved in the original project. So suing under contract law isn't an option. What options do people have? Well, it's only under the tort of negligence can you sue in this case. The law itself has made a distinction between residential buildings, where the owner occupies the house, versus commercial buildings. Now, we were going to look at residential buildings first and see what the rule is when it comes to residential buildings and owners of these residential buildings. So if the building defect results and you've got subsequent owners and all these owners are considered as, occupiers of the house, then the resulting defect is viewed as a pure economic loss. And the owners in this case would be reimbursed for the reduction in value of the building. So the Australian courts, they favour reimbursing owners that occupy the houses, even if you're talking about, the third or fourth owner of a particular house, when a defect suddenly arises and that house was built 10 years ago or 9 years ago, then the court would still allow that owner to be reimbursed for the economic loss that they suffered because of the defects. Now, the courts over here, what they're doing is that they're not enforcing the indeterminacy of the liability. Remember when we talked about the indeterminacy of the liability, setting up boundaries on how many people uh, the defendant in this case would be liable for. So the court would remove such boundaries for cases where the owner occupies the house. And an authority case for that is the one that you see highlighted on the screen in front of you. Now moving on to commercial buildings. It's usually a different rule. So for owners over here, they are mostly found to be not vulnerable to the risk. So it's all about the vulnerability. When we talked about owners that occupy the house, even when you've got subsequent owners and ownership changes, these owners are regarded by the law as vulnerable people. Whereas if you've got commercial investors and they're purchasing commercial buildings, then they are found to be not vulnerable to the risk. So there are two cases that you see on the screen. The first one is Walcott Street Investments and CDG. Now in that case, in that particular case, the court determined that the owner in this case should have used commercial mechanisms to protect themselves. So maybe added a clause in the contract, or maybe use insurances, etc., to protect yourself as an investor. So you're an investor. You're regarded by the law as being capable of protecting yourself. You can do that through looking through the contract and seeing the clauses that determine the liability and making sure that you're covered through these clauses. Another case that you see is the one involving Brookfield Multiplex and Owners Corporation. So in this case, it was determined by the court that the investors had the option of negotiating with Brookfield Multiplex on clauses that were related to defects and how Brookfield would be liable for fixing up the defects. But the investors failed to incorporate or to protect themselves against the risk. So it wasn't up to the court to protect them. They weren't found to be liable or vulnerable to the risk. And as a result, it's usually the case. It's not a solid rule, but it is usually the case that if you're considered as a commercial investor, so you're purchasing a commercial property, the law is less likely to find you vulnerable to risks, and it is hence less likely to protect you. You have to protect yourself, and you do that through inserting clauses in the contract, making sure that your liability is covered. Why is it important that we understand building defects and their implications um, in tort law? Well, it's all got to do with how the industry operates. Let's just hypothetically assume that the High Court allows the recovery of damages for pure economic losses by subsequent buyers due to defects in commercial buildings. So it's no longer just the owners that occupy the buildings that can claim for the defects, but it's also commercial investors. The ramifications are going to be massive on the insurance industry. So the construction industry in general operates based on this indemnity insurance concept. So you, as an engineer, as a builder, you cover yourself from any cases that can be brought up against you in negligence through indemnity insurance. So the insurance pays for you in the case that you're found to be liable to under negligence. Now, when the court allows commercial buildings to be treated as residential ones, and you're protecting commercial investors, there there's now going to be massive risks that the builders, the architects, and the engineers are going to be exposed to, and hence they would want to mitigate that risk to someone else. The indemnity insurance premiums are going to increase, and no one is going to afford any such insurance. So it becomes really hard to take part in this industry, and it's going to impact how the industry runs massively. So you'll find a lot of people not capable of paying their premiums, and hence they won't get indemnity insurance, and as a result, they won't be operating in the industry. And that's something that the law doesn't want to encourage. They want to. The law is there to encourage smooth, economical performances by, or it's there to allow people to operate in the industry in a smooth manner, and introducing a law that allows commercial investors to be protected would eventually lead to massive insurance premiums, and that's something that the industry cannot afford.